Bill, I thought of if you can touch, of course, comment whatever from this discussion so far, but a topic of utmost importance, I think, that is available, that is of interest to all competition lawyers, is always how one evaluates the competition agency. And I know and I read your article, so maybe if you can touch that, that'll be great.
Great. I'll just have
slides over here that I can look at as I go along. Beth and Doug have already framed this issue very well, and let me just add a couple of embellishments to the wonderful framework that they've provided. A key theme, especially in Beth's remarks, is that activity by itself is not a great measure of what you do. I had a sport trainer when I was in high school who had a sign in his office that said, activity is not the same thing as accomplishment. So that what we want to be able to assess over time is accomplish not simply how many things we've done, but to go back to Carly's presentation, there are really two things we want to assess. Are we doing the right things? Are we doing things the right way? Substance, process are the two focal points. Yeah, who should do this? Two focal points. One is that it should be done by the agency itself. Because I go back to Beth's and Doug's themes here, which is that nobody gets this right the first time. This is the equivalent of a computer program that needs recurring upgrades. And the upgrades are designed and based on experience. The agency itself should do some of this assessment. It should be part of its internal culture. But this is where co-production with outsiders is so important. Research institutions, professional societies, individual law firms, and the multinational and regional networks that Beth was talking about a moment before. And in this respect, the interaction with outsiders, with the private bar, with law firms, with affected companies is very important. I think in ICN, for example, it's only through the interaction with companies that we have come to learn exactly what a pre-merger notification program does, how costly specific demands for documents and information are. And by having that kind of interaction, it has permitted the agencies to think more carefully about which elements of process might be changed at no cost to the quality of regulatory oversight, but at a reduction of the burdens that both the private parties and the agencies themselves face. How to go about doing this? One element is meaningful agency disclosure. As Beth was saying, a clear definition of what the agency is seeking to do puts outsiders in the position of offering meaningful guidance and observations about the strength and quality of what the agency's done. So the agency has to be able to spell out, and I agree entirely with Boris, it's imperative for the agency to put key policy instruments into the public domain for broad commentary by all affected organizations beforehand. And as Doug said, that has to be a sincere gesture. It can't be a mechanical pro forma exercise, because in so many instances, informed outsiders will be able to teach the agency a lot about what it's doing. Another approach is to use audits, the peer review exercises that OECD and UNCTAD has been doing. The management exercise that OECD has sponsored under the supervision of Paul Mallion and Joe Phillips, public consultations and discussions where you engage outsiders in your views, and benchmarking with others' experience, be it merger review or other areas. If I were a relatively younger agency, I'd want to pick a slightly older and more experienced and good agency to work with, much in the way that you become a better tennis player by playing a somewhat better tennis player. I'd want to join myself up with other agencies, not the oldest, but others that are doing a particularly good job. In this respect, just looking very generally in the region, Turkey and Hungary are two great examples of agencies that are both relatively new, have built good programs, as Paul was pointing out before in his presentation on compliance. A wonderful interaction, I think, with the business community, with the agency that's developed a very strong program in Hungary. Turkey being another good example. I'd want to benchmark myself with another institution that's relatively new, if possible in similar economic, social, political circumstances broadly defined, and use that as a way to see how I'm doing, because I'm keenly interested in hearing from someone who's doing a good job, who's been through the same process I have been recently, in addition to the older institutions. What do we look at? Again, two dimensions, process and substantive outcomes. Process might be the easiest to observe. That is, are you getting a good set of observations from inside the agency that test evidence well? The European Union's policy reforms, the European Commission, DG Comp, all of the adjustments that we've been talking about today. A good example of an agency that recognizes that good substantive design is going to affect the quality of outcomes. And so much of what DG Comp has done, with the great admiration of outsiders, has been to make the testing of evidence internally more rigorous than it was before. But another thing that one can examine is the process by which things go through the agency. And having a data set that carefully tracks the age, process, and status of matters is a good way to overcome what Dag was referring to before as case team capture. If you simply allow the case holders to fall in love with their case and not to abandon a case that's gone bad, the file will be open forever. With some embarrassment, we recently closed a file that had been open 10 years. It was a conduct-related investigation, a file that had been there 10 years. I think a sensible decision could have been made after year 3, year 4, all right, year 5, to put it to sleep. But instead, the sheer inertia of the case team capture project kept it going. As a rough rule of thumb, you should never have a matter open that long. Things shouldn't take that long. If you have a good internal accounting mechanism, an electronic database that brings these to the attention of senior management on a regular basis, and you track how long things are keeping, you'll get lots of the rubbish out of the attic, and you'll have a process that is better streamlined and able to handle things. The harder thing to evaluate is the quality of substantive programs. But I think about Paula's and Milos's and Kathy's comments about merger review and the treatment of efficiency claims. One thing you can do is take what might be called close calls, where you've let something go through that involved a difficult judgment about whether there was a good efficiency argument or not. If you let the deal go through, you can go back and see if your assumptions were well justified. Did you make a judgment, to use one of Paula's factors before, about entry? Well, did entry happen? Who came in? How fast did they come in? How quickly did they take consumers away from an incumbent? What does this tell you about the kind of evidence that you're going to rely upon to evaluate an entry claim? Same thing with efficiencies. That is, you can take mergers, for example, that you allowed to go through, and you can certainly take instances in which you've adopted complex remedies and judge how difficult it was to actually put them in place. So in so many respects, I think this is a field in which it is less important precisely where you begin, far more important to track progress over time. And the good agencies are going to be those that are engaged in a continuing process of evaluating how they do their work, because this is the basis for making the periodic upgrades that make a difference. And fortunately, no agency has to go through this on its own. As Beth was saying before, there's a host of international experience that can be brought to bear very usefully in designing both the evaluation methodology itself and identifying promising ways to improve.
Thank you, Bill. I think we